In this video, we will discuss 4 ways that you can beat a theft charge in court. That's coming up right after this. Welcome back to Gustitislaw. If this is your first visit, I'm Steve Gustitis, and this is my channel. Here at Gustitislaw, our passion is to create video content for you that helps you understand how to successfully navigate the criminal justice system, how to manage encounters that you may have with the police, and how to defend criminal charges. Consider becoming a subscriber to Gustitislaw by clicking on that capital black and white G down in the lower right-hand corner of the video screen. And when you click on the notification bell, you'll receive notifications whenever we upload a new video. I also enjoy answering your questions and responding to your comments, so add those down in the comments section below. How do you beat a theft charge in court? Well, even though theft charges come in all shapes and sizes, there are some common issues among theft cases that you can use to help challenge the prosecutor's case against you. Discuss these with your criminal defense lawyer to give you the best possible chance of beating your theft charges in court. In all criminal prosecutions, the prosecutor must prove beyond a reasonable doubt the identity of the alleged offender, and theft cases are no different. In other words, a prosecutor must prove that you were the person who acquired the property without the effective consent of the owner and with the intent to permanently deprive the owner of that property. Any reasonable doubt about the identity of the alleged offender will lead to a jury verdict of not guilty. In a theft case, the prosecutor must typically prove that when you acquired the property of another, that your intent was to permanently deprive the owner of that property. In other words, the prosecutor must prove that you took the property of another without their consent with the intent to keep it permanently. We have used on occasions in the past, and successfully I might add, what I like to call the borrow defense. In the borrow defense, we established that our client's intent at the time they acquired the property of another was not to permanently deprive the owner of the property, but rather to borrow the property and to return it at a later time. In those cases, we've been able to shed doubt on our client's intent and challenge the prosecutor's case successfully. Another key element in the prosecutor's theft case is to show that the property was acquired without the effective consent of the owner. In other words, if you possess the owner's property with their consent, it is not theft. We like to call this the permission defense. For any time that you have possession of the owner's property with their consent or permission, the prosecutors cannot successfully prosecute you for theft. Any reasonable doubt about whether or not you had the permission or effective consent of the owner to possess their property will lead to a jury verdict of not guilty. Lastly, any evidence acquired by the police that they plan to use against you in court, but was acquired in violation of your Fourth Amendment rights to be free from unreasonable searches and seizures, can be suppressed from evidence in court. And that's another way to beat a theft charge. In the same way, your Fifth Amendment right to remain silent might be used to suppress incriminating statements that you made to the police or to others. If the prosecutor's principal evidence of your intent is an incriminating statement you made to the police, and if you can persuade the trial judge to suppress that evidence from court, you might be able to beat that theft charge nevertheless. If you have any comments or questions about how to defend or beat a theft charge in court, add those down in the comment section below, and we can begin a discussion that may help others as well. Don't forget to give the video a thumbs up today if you liked it, and share it on your other social media platforms. Thank you for visiting, and thank you for watching here at Gustitislaw.